The WTO case that was taken by the European Commission against the US government with respect to a provision relating to the public performance of musical works using home-style receiving equipment. The EC1 and the WTO panel found that the US was in breach of its international obligations. And then there was an Australian judge who used to be president of the Australian Copyright Tribunal, who gave the decision with respect to the damages that the US had to pay to the European Commission for the breach of their treaty obligations. Justice Shepherd, I think you remember Justice Shepherd. Unfortunately, he only awarded $1 million a year, which we thought was very undervalued. But we were definitely participating in that to try and ensure that, particularly a jurisdiction like the United States didn't introduce exceptions that were unfair to rights holders and made it much more difficult for them to enforce their rights generally. So I think this is the whole thing about limitations and exceptions. It is, as Sophie was saying, always a difficult balance between the rights of holders and copyright owners to protect their legitimate economic and moral interests, and the rights of users to have access to information. So I think Katie went through the US fair use exception, which is essentially a broad, flexible exception, case by case. And there is a list of fairness criteria and illustrative purposes within the provision, and I've given you the whole provision there. And in determining whether or not the use, you look at the purpose and character of the use, the nature of the work, the amount and substantiality taken. In Australia, we have a common law English series of exceptions that are a limited listed number of purposes for which free use can be used of materials. So we have fair dealing for a number of purposes, including your personal research or study, with certain factors involved in determining whether or not that's fair. Again, for reporting the news, for judicial proceedings, for giving legal advice, for the incidental filming of artistic works, for criticism and review, for reporting the news, all of those provisions that are in the Berne Convention and in jurisdictions like the United Kingdom, like Hong Kong, like Singapore, like Australia and New Zealand. It's a defined closed list for certain purposes. Australia has quite a unique, however, range of statutory licenses for educational use that I mentioned, I think, earlier. They include making multiple copies of reasonable portions of published text for educational purposes, so to distribute to students. So under the proposed exceptions with respect to distance education, for example, both of those would be licensed and covered by a license, making copies of reasonable portions of text for educational purposes. They would be remunerated uses going back to the publishers of that material. And that's because I think in policy it's recognised that there is a very substantial and important sector of the copyright industry, which is educational publishing, so that the people who invest in the creation of works that are consumed in an educational context have the right for remuneration to ensure that that sector of the industry is encouraged and given reward. There have been a number of different sort of considerations of whether or not in Australia we should change our fair dealing provisions, our limited list of exceptions, and go more towards the US fair use open-ended provision. The first one was in 1996, the Copyright Law Reform Commission undertook a simplification review of the Copyright Act. I don't know if any of you have seen the Australian Copyright Act, but it weighs about 7 kilos and is about 700 pages long. So it's a lot of fun for lawyers like us. But that's mostly because the statutory licenses, not only for educational purposes, but the ones for print handicapped people, so making copies for people with visual disabilities, that is also in that Act, as well as provisions allowing government use upon payment of equitable remuneration. So they're not free exceptions, although the print handicapped provisions are actually free currently. There's no charge made for that, but there are provisions that you have to make in terms of making copies for the visually impaired. So that comes, then that allows Australia to accede to the new Marrakesh Treaty for use of copyright material by visually impaired people. And later, the simplification review said, yes, there are too many exceptions and it takes up too much paper. We're killing too many trees by printing the Copyright Act. We should just have a consolidation of all the exceptions into an open-ended model like fair use. But that wasn't accepted by the government. Later in 2000, the year 2000, the Intellectual Property and Competition Review Committee, the ERGAS report, looked at whether or not fair use would be of benefit to the copyright balance. And it found that the significant transaction costs in changing the law and introducing a new uncertain system of exceptions would far outweigh any benefits to copyright holders and consumers. And then later again in 2005, the Attorney General undertook a study in the context of the Australian-US Free Trade Agreement, looking at, because we were looking at implementing some of the provisions in, for example, the safe harbour provisions for telcos and internet service providers that were under American law. The government also said, well, why don't we look at whether or not we should also adopt, again, fair use? So they had another study on fair use and other copyright exceptions, comparing them to fair dealing and whether or not fair use operates in a much better way in the digital environment. So they didn't enact any changes at that stage. Again, there was the problem about, yes, fair use is much more flexible, but in the marketplace and for rights holders and consumers, certainty is probably much more important. And there are also concerns about whether or not introducing fair use would be in breach of the three-step test that Katie was talking about. But after that 2005 report, the Australian government did introduce some more exceptions, and they were a fair dealing for time and format shifting, as well as a fair dealing for parody and satire. So yes, we did extend our copyright exceptions in that regard, but not going as far to adopt an American-style fair use. And the most recent one has just been this year, the copyright in the digital economy, looking at all of the exceptions, including the statutory licenses and how they apply in the digital economy. Hargrave's report in the United Kingdom is a very significant international review of copyright law, again looking at the digital economy and the effect of copyright law. And there, the Hargrave's report concluded that they found significant difficulties in attempting to transpose a US-style fair use into European law, because of course UK law is subject to European directives with respect to copyright law. And again, the three-step test was referred to, that, exceptions can only be limited to certain special cases. So fair use, by its very flexible nature, is not limited to certain special cases. And the second part, which don't conflict with the normal exploitation of the copyright material, so that's looking at existing markets for copyright material. They're not conflicting with licensing that is currently happening, and do not unreasonably prejudice the legitimate interests of the rights holder. That's also looking at, I think, future markets that are to be developed in terms of digital consumption and how rights holders will be remunerated in the future with respect to that. So the concerns that have been raised with respect to the latest provisions and recommendations regarding fair use, adopting a broad-style US fair use and deleting all of the other free exceptions, having them all come under fair use. Again, it's the three-step test, whether or not it is viable internationally in terms of our treaty obligations. The question of the expense and the uncertainty, and in a way that it is effectively the government delegating policy development in the balancing between consumers and rights holders to the courts. And, as KT said, I've been thinking about if they do introduce fair use in Australia, and a lot of my friends are thinking, well, we're going to go back into private practice because I want to be rich. I don't want to work for a non-profit company working for songwriters when I can go and litigate fair use and make a lot of money, because that's where all the money will go. There are, of course, significant differences in terms of copyright law in the US, that freedom of speech is incorporated in their Bill of Rights, and also the US Constitution gives the purpose of copyright as the progress of science and the useful arts, whereas our Constitution, copyright comes under the plenary powers of peace, order and good governance. So the whole focus of copyright and the factors that may be taken into account in assessing the fairness and the balance between the rights of copyright owners like songwriters and publishers and consumers and businesses in the digital age that are using copyright material, may come from a different point of view. The other significant difference between Australia and the UK and Hong Kong, etc., and the US is that under US law, there are provisions for statutory damages. So if there is an infringement of copyright and there isn't a fair use, then copyright holders are able to recover very significant damages, whereas under our laws, under common law UK style, the damages relate to either the unfair gain that the user has made or the economic loss that you have suffered. So it's not the same level of statutory damages that are awarded under the US. And of course in the US there is a history of litigation and a much more litigious culture. As KT said in some of those quotes, that fair use is just an excuse to hire a lawyer. So there's some concern about us going down the path of, American solve everything by litigation. Rather, it should be the government that is setting policy and monitoring the balance between the rights of copyright holders and users. Also, one of the factors that doesn't exist in our law as a concept, but does under US fair use, is this question of transformative use. Maybe the question of transformative use for the creation of user-generated content. For example, you mash up an existing work, or you take a song and put it on a video that you've made. So you're creating a new work out of another work. And that's one of the factors that in US copyright law will go towards whether or not a use is a fair use or not. Those sort of concepts don't exist under our jurisprudence, under our law. So, you know, in the example of somebody making user-generated content, yes, in terms of the person taking the song and putting it on a video of their cat falling down the stairs, that may not be a commercial use. But once they upload it onto YouTube and Google put on advertisements and start making billions and billions and billions of dollars out of it, that is very much a commercial use. And they are the evolving markets that we are trying to capture on behalf of our rights holders. And that's why it's very significant that in Australia, that all the lobbying for this most recent inquiry into fair use came from Google and from Google-funded lobbying bodies such as the Australian Digital Alliance, the Australian Library Information Association, the Pirate Party, all of the bodies that Google funds to try and establish fair use in our territory so that they can then say, okay, this user-generated content, we're not going to pay for that to rights holders anymore because it's fair use. The transformative use also was another factor in the Google Books case. I don't know if any of you know about that, but that is where Google had agreement with libraries to go through and scan all of the books in their libraries and put it in their huge database in the cloud. They did that without permission from the publishers or the authors. And they did it also with a view to indexing all of that. Yes, a very useful use of that material, but not without permission and without allowing those rights holders to share in the economic benefits from the exploitation of those works that Google was going to make. So that is clearly a commercial use that should be remunerated, and litigation is ongoing because Google, you know, just said, let's get 5 million books from around the world and see how we go. You know, we won't ask permission and we'll see because they'll have to sue us because we say it's fair use. So that's one of the greatest fears we have, that we will have individual songwriters going up to Google and saying, oh, we want to be paid for this commercial use because you're making billions of dollars and my music and my content is on your site that you're making money out of. And Google will say, no, it's fair use. And we know how many good lawyers they've got because they pay a lot of very good lawyers. So you probably won't win that case if you have fair use. So yeah, the fairness factors are also, can be problematic into whether or not there are other fairness factors if it's a non-exhaustive list. You know, there are recommendations that the fair use could give illustrative purposes like it does in the US, like our exceptions already do for reporting the news, for parody and satire, etc. But having a list of illustrative purposes doesn't necessarily give a coherent policy basis as to why certain exceptions should be free and that rights holders shouldn't be remunerated for those use. So yeah, in our jurisdiction, we're often looking at fair use, and definitely fair use is touted, particularly by US corporations like Google, say this is going to solve and make everything a lot easier in terms of, you know, digital marketplaces that are evolving. But we still want, from a rights holder's perspective, we want to be in a position where we can be strong and still capture evolving digital markets. So, thanks.